Hi, everyone. Thank you for joining us tonight. I am Kelsey with the Council on Developmental Disabilities. Um, Thank you for coming to the fourth and final presentation with Gordon and Matthew. Sorry. Um, Tonight, they're going to be discussing life planning and all that comes with it, caring, family support, everything that comes with it. Before I turn it over to them, I do want to remind you that you should check our social media pages, Facebook, Twitter, Instagram, and our website for future events. So if you're ready, Gordon, take it away.
All right, thanks so much, Kelsey. And we appreciate so much the great works of the council, the Louisville Council on Developmental Disabilities, making this possible, sharing information over these last 4 weeks. And this evening is the fourth and final installment, and it's going to pull together elements from the last 3 Tuesday evenings that Matt and I have enjoyed sharing with you. So I'm Gordon Holmes. I'm a certified financial planner and fiduciary and special needs planner. So help families with legal, financial, and government benefit issues related to the special needs journey. I'm also a parent. And then Matt's here with me. And Matt, you want to share just a moment for you?
Sure. So my name is Matthew Gooden. I'm a special needs attorney here in Louisville, but I assist clients across Kentucky. Like Gordon, I have a personal connection to this area as well. I have a sister, Rose, with Down syndrome. I also have an aunt who has an intellectual disability. For the past 12 years, I've coached Special Olympics. So all of those pulled me into this area. So my practice focuses on estate planning for families who have children with special needs. All right. Also assist families with guardianship and advise them on government benefits as well. So, Gordon?
All right, wonderful. I'm going to go to share screen, and then we will both participate in this evening's PowerPoint presentation. So here we go to share screen. Boom, boom, boom. And now you hopefully see on the screen, creating a special needs legal and life care plan, or you do now. Okay. This will be the topic for this evening, and Matt's going to lead off, and then part of the way through, I'll step up and kind of bring us home with this. I do want to mention that, of course, it's understandable that being the fourth and final installment of the 4-night series, we have reserved time at the end for questions. And so, so as to not spring it on anyone, unlike the past 3 sessions where we have to work hard to land it on time to get through all the material. Purposefully, we planned the 4th session so there is a bit of time at the end for questions. And I mention that because if any of you want to look over your notes from the last 3 sessions and determine maybe what questions were not answered or what questions you have, or kind of like here's an opportunity to ask the expert of sorts, then perhaps as we're moving through this evening, you'll want to glance through that and come up with some questions. And to summarize, the first session was on government benefits. So if you have any questions on government benefits, tonight's the night. Social Security, SSI, SSDI, adult child benefits, drawing off of parents, and employment and Social Security, and all of that. Even survivor benefits, if there's anyone out there that either has that situation or is potentially facing it. Medicaid and waivers and Medicare and so forth. So the first session was certainly loaded with government benefits. The second session both dealt with guardianship as well as ABLE accounts. And so any questions on either of those areas, Matt and I will be delighted to entertain this evening. And then the session from last Tuesday evening, of course, focused on the many special needs trusts and how they play a critical and pivotal role in the special needs planning process. I was just on the phone with an attorney from Evansville earlier today, discussing of the menu of special needs trusts, what was appropriate in a particular person's situation. And it just reminded me how blessed we are to have options for planning that did not exist largely in prior generations. And so Matt and I are carrying the torch for all that have been hard fought, and things that are available to us that were not available as recently as 30 years ago. And so a big part of this education series is what's changed and the reality that we have today and the opportunities available to both protect and provide for and plan for a wonderful future for our loved ones with special needs. So any questions on special needs trusts? Again, tonight is your night. So please keep those things in mind. And Matt, if you'd be so kind to lead off here with the life care planning disclosures as usual. And there you go.
All right. So as Gordon mentioned, tonight we're going to talk about life care planning. And our goals for tonight are to pull a lot of the information from our previous sessions together so that you guys can try to connect the dots between the topics and see how they are interrelated. And then second, our second goal is to pull a lot of what we've talked about and put them in practical terms so that you can see how the topics apply to your particular situation and to see what the process would look like if and when you walk through it and you begin to plan for your loved one with special needs. So think of a life care plan as the coordination of efforts from you, your attorney, your financial advisor, and other professionals, and your family and loved ones to create a cohesive plan that provides for both your needs and the needs of your loved one with special needs. So that's what the life care plan idea encompasses. So in the special needs context, there are often many different people involved. This can include a special needs attorney like myself, a financial advisor like Gordon, an accountant, bakers, life insurance agents, retirement account administrators, also social workers, physicians, therapists, a whole host of individuals. And in order to make things as efficient as possible for your loved one with special needs, all of these individuals have to be working together towards a common goal. Everyone has to be on the same page. That will allow your loved one with special needs to live the fullest life that they can, and it will maximize the benefits and services available to them, and also hopefully reduce stress and disruption once you pass away and are no longer the primary care provider for your loved one with special needs. So Gordon and I are obviously two important pieces of the puzzle, and our goal is to begin building this integrated plan with you. So our life care planning timeline. Depending on where you are in life and where your loved one with special needs is in their life, will determine what items you need to be thinking about when it comes to creating this life care plan. So if we think of life from 1 to 10, 1 being birth, 10 being death, if someone at 7 starts their plan, it's going to look much different than someone if they started at number 2. So depending on where you're at in life, what your situation looks like, what your loved one with special needs situation looks like, will determine what your life care plan ultimately looks like. So if your loved one with special needs is under age 18, you need to be thinking about Medicaid waivers, which we talked about in week number 1. You also need to be thinking about Social Security survivors benefits or dependents benefits, SSDI benefits. Again, we talked about that in week 1. Early intervention programs, so that birth to age 3 range. You also want to look at IEPs. So while your loved one with special needs is in school, you want to work on the IEP issue so that they're getting the most out of their time in school. And then transition planning. So once they get to age 14 to 16, they're creeping up on adulthood at age 18. What does that process look like for them? And then also ideally, we would want to start to build a legal structure during this time as well. We shift to after 18. Age 18 is an important date for many reasons. If you followed along with us throughout the series, that age has come up often. So once your child with special needs turns age 18, we want to be looking at some other things, potentially SSI, supplemental security income, potentially if they're eligible. We want to look at guardianship and the alternatives to guardianship, because again, now they're an adult. Legally speaking, the law assumes that they can make decisions for themselves, but sometimes, especially in our context, that's not always the case. They need some assistance with decision making. That's where guardianship and the alternatives come into play. If we beforehand have already built a legal structure, we want to review it. If we haven't put a legal structure in place, then we obviously want to begin putting it in place. We want to look at Medicaid and Medicare, and then also Social Security benefits again. As your loved one with special needs ages and as you age, they may transition from SSI benefits to SSDI benefits, which we've talked about, the 3 triggering events for that to occur. So we want to be cognizant of that. And then also, we want to look at college and employment issues. We want to look at housing. As your child ages, certain items will become more relevant. And as you age, your child may be eligible for certain things that they wouldn't have been eligible for when they were younger. So just keep that in mind. Depending on where you are in life will determine what items you need to think about when you're assembling your life care plan. So our 10 comprehensive planning steps. The first thing we want to do is address any primary issues that you can come up with. So are there any potential issues you can think of at the start that need to be addressed? An example, a lack of a trustee or lack of caregiver options. So you know that you don't have any family members that you can think of that can care for your loved one. That's a primary issue that we need to think about from the start. Second step, we want to create our life care plan vision. So what are your hopes and wishes when it comes to your dependent with special needs? What do you envision them doing? Where do you envision them living? Who do you envision them living with, if anyone? So those are things that we want to look at. Also, the vision, do you envision them working? If so, where do you envision them working? So that's in step number 2. Step number 3, again, guardianship and our alternatives to guardianship. Focus on the dependent with special needs' ability to do things for themselves and make decisions for themselves. So that's obviously an important aspect for our purposes. Step number 4, we want to identify financial resources. So we want to do an accounting of both your assets and your dependent with special needs as assets, if any. Again, if they're working, obviously they may have some assets that have accumulated, or they may have benefits that have accumulated. So we want to look at that. Step number 5, we want to prepare our life care plan costs. So we want to try to get an idea of how much money our loved one with special needs may need for the rest of their life. Now, this isn't an exact science, but the idea is that it gives us a rough idea and a good starting point. And this can be a good guiding principle to determine how much money we could potentially leave to a special needs trust. So that's how we tie this in with the trust aspect. So things that will determine the cost and how much we should put into a trust potentially are going to be the age of your loved one with special needs, their diagnosis, and their required level of care. So if they require 24/7 care, obviously the costs to provide for them is going to be much higher than someone who is fairly independent, high functioning, can live on their own, and can do many things independently. So we want to take those factors into account. 6, we want to prepare a letter of intent, which we'll talk about more in a couple slides. We want to also prepare legal documents, so special needs trust, wills for the parents or other trust documents, powers of attorney, all those legal instruments, so that your vision can be carried out. 8, we want to review the need for the special needs trust and ABLE account. And again, these are the primary vehicles for leaving money or assets to your loved one with special needs without jeopardizing their eligibility for public benefits. So that's why they're very important for us. Number 9, hold our family meeting. Again, this is to ensure that everyone is on the same page. That's our key takeaway. We want everyone or as many people involved as we can, especially from the family, so that everyone's working together, everyone understands what the goals are and what we're trying to achieve, and we can all work together towards that common goal. And then, of course, we want to review our plan annually to account for life's changes. So this is not something that we want to create today and then set aside and not come back for another 10 years, 15 years, or 20 years. It's something we want to continually pick up at least annually to make sure that it's accurate and up to date. So our 4 focus areas, honing in a little bit in our special needs planning process. Our first is our family assets and planning. So we're balancing the needs of all the family members. We're deciding how much should be left to the child with special needs versus the non-special needs children. We're coordinating resources, and we're also looking at our caregiving planning and deciding who is going to assume some of the caregiving roles after mom and dad are no longer here. We're also going to look at employer benefits, so life, health, and welfare benefits, retirement plans, deferred compensation. These are our potential funding sources for the legal planning, and we'll talk about that more in a minute. Our number 3, government benefits. So of course, this is important. They're likely going to be involved with our loved one with special needs. Our means tested benefits, SSI, Medicaid, Medicaid waivers, and then our entitlement programs or non-means tested benefits, such as SSDI and Medicare. So obviously, those are going to be an important aspect for our planning purposes, and those focus obviously on the dependent with special needs. And then lastly, our legal planning. So this is putting the necessary legal documents in place to carry out your wishes. We've talked about these: wills, advance directives or other medical documents, special needs trusts, potentially ABLE accounts, and all of those. So our the first of our 4 focus areas is our family assets and planning. This is important, and what we want to do when we're creating our life care plan from the beginning, we ideally would want to host a meeting with family and friends, particularly those who you want to be involved in the plan. And I believe I heard this story from Gordon about a family who he met that they were discussing who was going to take over the caregiving responsibilities once mom and dad were gone. And husband and wife had someone or a couple people in mind and were dead set on that. And following the meeting, they left and spoke with that individual or those individuals and came back and were very saddened to hear that the people declined to accept that role. And unfortunately, that is sometimes a reality. And hopefully, which we're going to talk about in a second, a letter of intent can help with that, because one of the concerns from family members who are tasked or at least asked to take on this caregiving role, it's obviously new to them. They're not comfortable, at least they're at least not familiar with carrying on that role, most likely. So they have a lot of questions, a lot of concerns. So the letter of intent, which we'll talk about in a second, provides a lot of information to them, allows them, hopefully eases their stress, eases their concerns, and provides a lot of information to them so that they're more willing to accept that role, and you don't find yourself in the situation where the person that you think is going to take over chooses to decline, and then you're left wondering who you're going to pick. So, hosting a meeting up front, having these conversations early on is definitely better than just assuming that someone's okay with taking over. So, you want to share your information about your loved one with special needs and also what you envision their future looking like, and what your expectations and wishes are, and discuss any concerns that you have. So those are very important. That's what we want to do from the start, so that everyone's on the same page. So our letter of intent, which we just alluded to, this is our most important non-legal document in the special needs planning process. So not a legal document, but it may be considered by the court when they're trying to determine your wishes concerning your loved one with special needs. So it's designed to provide as many details as possible about your loved one with special needs, um, to their future caregiver. So it allows that person, the future caregiver, to step into your shoes and basically pick up where you left off. So hopefully this will minimize stress, minimize disruptions, once that transition in the caregiver role occurs. It accounts for your current situation, but it also lays out your hopes and wishes and your dreams concerning your loved one with special needs. So, what do you envision their future looking like? What are your expectations for them, etc.? We, of course, want to update this regularly. We want to complete it as if something were to happen tomorrow. That way, if something did happen, it would be up to date, and your future caregiver would have the most recent information to make decisions on. So, why do we create a letter of intent? Well, it leaves those specific instructions that will familiarize that person with your loved one with special needs, because again, they may not be familiar with the person. Hopefully they are, but they may not be as familiar as you are as mom and dad, and they may not be familiar with caring for someone with special needs. It might be new to them. So when do we want to do it? Again, it's a working document. It should be completed immediately so that we have this information out there, and we want to continually update it as frequently as necessary, at least annually. How do we do it? Well, Gordon and I both have templates, but don't be afraid to go beyond what's listed there. So if you are going through it and completing it, and you feel that other information that's not necessarily asked on the letter of intent is necessary, feel free. The more information, the better, because it's all going to be information that is going to your loved one with special needs' future caregiver, to assist them with caring for that person. So, is more information, the better. And then, who should be involved in completing the letter of intent? So, you want to get as much input from other people as possible, especially those future caregivers. Ask for their opinions and get their input, and your loved one with special needs, if they're able to um, um, speak and express their wishes or their vision and how or who they prefer to be with, etc. Certainly, we want to implement that in our letter of intent as well. So, um, the letter of intent can be a huge stress relief to that future caregiver, which is why it's very important to have this information to complete the letter of intent and to keep it updated. So our second focus area is employer benefits. And this is primarily focused on you guys as the parents. So these items often become the funding source for our life care plan. So this includes Life insurance, retirement accounts, those are our two main items. Group life, short and long-term disability benefits, employer retirement plans. And it's important to note with the retirement plans and the life insurance, the key thing to remember with those, they have designated beneficiaries. So if we want either of those items or a portion of those items to go toward our life care plan, meaning we want those items to um, help pay for or cover some of the cost for a loved one with special needs as they go through life, then we want to list as the beneficiary our special needs trust for the child with special needs. It's important. We don't want to list our loved one with special needs as the beneficiary because they will get the money individually. That will cause a public benefit issue, most likely, because it's almost a guarantee that the money or the amount that we're dealing with is going to be over the $2,000. That's the most they can have for benefits eligibility. So keep that in mind. You do want to look at your retirement plans closely to see whether or not they become available upon your disability. So the language in the plans relating to disability is important to determine when you can access the funds. So be sure to look at that. Any supplemental benefits that may be involved. And then other benefits here, life insurance is the big one. That can be through your employer or through a private third-party provider. And typically, information on these benefits, especially if it's through your employer, can be accessed through your human resources representative. If it's a life insurance agent, retirement account administrator. So those are the contact persons that you should be reaching out to if you have questions on these. Because the idea is that we want to assess what benefits from your perspective are out there and see how we can implement those into our life care plan from a funding standpoint. And again, this is primarily coming up with naming those items or naming the special needs trust as a beneficiary of these items. So our third focus area is government benefits. This is somewhat of a review from week number 1. So first we have our entitlement benefits or non-means tested benefits, which are where eligibility is based on some factor other than need. So our Social Security benefits, whether they're retirement benefits or our disability insurance, SSDI benefits, that's where eligibility is based on our qualifying work record. So you have to have worked enough, earned enough credits to qualify. We're also looking at other types of Social Security benefits, so family benefits, spouse and survivor benefits, which again, we talked about. Children's disability benefits are adult child benefits if disabled prior to age 22. Medicare, and again, that's based on age and or disability. So those are our entitlement benefits. Switching gears, our public assistance benefits. These are our means tested benefits. And this is where eligibility is based on need. So you have low income, low resources, and therefore you need the benefits. So for all of these, you have income and resource requirements you must meet in order to be eligible. So examples, supplemental security income, excuse me. Allergies have been difficult this week. So we have supplemental security income, SSI, Medicaid, and the Medicaid waivers. We also have our SNAP benefits or our temporary assistance for needy families benefits or our CHIP benefits. So these are on the public assistance means tested side of things. So we want to assess, again, our goal here is we want to assess what government benefits are available for your loved one with special needs, what impact those benefits can have on their life, and how to plan for their future eligibility for benefits, or to maintain their continued eligibility for benefits if they're already receiving those. So that's our main goal when it comes to the government benefits side. So now Gordon is going to take over and go into a bit more detail on those entitlement benefits versus public assistance benefits. And then at the end, again, we'll talk about how to pull this all together, the legal structure in order to carry out your wishes in your life care plan. Gordon?
Thank you, Matt. Let's see here. There we go. Okay. So on the entitlement side, typically entitlement benefits are created as an outgrowth of one's participation in a program. That can be in the form of paying payroll taxes, such as FICA taxes, et cetera. And the taxes can be paid in by the individual with a disability. And it comes as a surprise to many people that it only takes a few years of part-time employment for an individual with special needs or disability to be insured for Social Security disability benefits on the entitlement side. So most often Social Security benefits start of an SSI nature, which is the supplemental security income. And then over time, either because of earnings and taxes paid by the individual with a disability or their parents, they transition from SSI to SSDI. So most commonly, SSI is either from birth all the way up or starting at age 18 through maybe age 25 or 30, depending upon the situation. And then again, eventually transitioning to Social Security disability benefits. And there are differences between those two. They're both designed to provide a monthly stipend to assist with food and shelter costs, that type of thing. But because SSI is a means tested benefit, as one's earned income goes up, the SSI typically goes down, as opposed to Social Security disability, where largely Social Security disability benefits are in addition to what earned income an individual with or consumer with special needs has. So it's learning what the guidelines are, what income, earned income limits to stay under, and you know what the rules are, so that you can engage in such a way to maximize on these opportunities for benefit or support. So as far as one drawing off of themselves, again, one can become eligible as a result of paying FICA taxes, paying into the system. A small amount of income can rack up eligibility for Social Security disability. As little as about $500 per month is all that's required. Again, about $500 per month in order to accumulate 4 credits or 4 quarters towards Social Security disability each year. So literally, if a child were to come out of high school and be employed by the time they're 19 or 20 and work part-time, then by 23, they could be eligible to draw Social Security disability benefits from themselves. And there are reports available through the Social Security website where one can literally monitor their progress toward being insured for Social Security disability benefits. Okay, then in addition to benefits one can become eligible for as a result of their own income, there's also benefits that an individual with special needs can be eligible for, drawing off of most commonly a parent's record. This can be an adoptive parent. It can be a custodial parent, biological parent, in some cases step parent. So there's a variety of parents that can play the role, and the adult consumer with special needs has the ability to draw off of their record. So there are 3 triggering events that enable our child or dependent with special needs to draw off of our record. One is retirement that you see on the screen. And so when that adoptive, biological, custodial, step parent, et cetera, retires, then it is possible for the child with special needs to start drawing off of their record. So depending upon what that record is for the parent, the benefit for the child can be substantially more than SSI. So usually there's more than one parent that they can draw off of. Sometimes there's actually even more than two, depending upon blended family status, et cetera. But on the retirement front, the maximum typically an individual with special needs can draw off of a parent's record is 50%. Most often that is 50% of the full retirement age benefit. So it's pretty substantial in many cases. If the parent is looking at age 67 for full retirement age, and Social Security suggests that their monthly retirement benefit might be $3,000, then the child with special needs, the probably adult child at that point, could potentially draw as much as $1,500 per month. Again, $1,500 a month, almost twice the SSI limit. And that's again drawing off of a parent's record. So it is interesting. I have been focused on special needs planning now for about 23 years. And 23 years ago, it was primarily planning that we did for young parents. But over time, our children with special needs have grown up, and from one family to the next, like the last meeting I had before this evening's workshop was a family where the youngest child, age 2, has Down syndrome. So this youngster with cute as a button, so often that's the case, but this young boy with Down syndrome at age 2, and we're planning. But in recent years, it's equally common to work with parents whose child with special needs is in their 20s, 30s, 40s, or even older. So in the same day that I had a Zoom meeting with a family with that 2-year-old with special needs, I had a Zoom meeting with a family where the daughter with special needs is 64. So all the way from age 64 to age 2. So you might be wondering who's left to plan for the 64-year-old, and the answer is her 94-year-old mother. And so we had a 94-year-old mother participating in the Zoom meeting, seeking help with planning for her 64-year-old daughter with intellectual disabilities. So the breadth is just so wide, and it's all over the board. And it is 2-parent situations, it is single parent situations, divorced, remarried, it is siblings. That call today with a 94-year-old mother and 64-year-old daughter with special needs also included 2 sisters. And so we had a sister and brother-in-law, another sister who's single, and the 94-year-old mom. And so very much like Matt was saying a moment ago, it's a family affair. The whole family was involved in the meeting, and it just goes to show the variety of situations. So retirement is one of the triggering events where if a parent retires, most often we see that anywhere from age 62 to 70, then it has implications for the child with special needs. An additional triggering event is disability. And I actually had a call this week where a parent was seriously evaluating whether to go off on disability or not based on medical issues that they were having. But if a parent does pursue Social Security disability benefits, it is a triggering event, and therefore there are implications for their a child with special needs. So most of the time, not always, but most of the time when a person pursues a disability claim, they're older, meaning they're at least in their 30s or 40s, this type of thing. But when a parent draws Social Security disability, then in most cases, their child with special needs is going to be drawing right along with them. So again, there are implications for us as parents as to when we want to consider retiring, and also implications for our child with special needs if we were to pursue a disability claim. Then to the right, family benefits. So family benefits, this is primarily a focus on benefits for family upon the death of a loved one. And we certainly have seen people pass in the last 16 months due to COVID. So we have one family that we're working with right now where the father at only the age of 52 obtained COVID and passed away in 4 weeks. It only took 4 weeks to take him down. And he passed away in February or March. And so for the last 2 or 3 months, we've been trying to work with Social Security, but it has been rough with Social Security for the last 15 or 16 months. Missed telephone calls that just were scheduled but didn't happen, and delays in responding to claims, and claims being delayed, evaluations delayed, meetings by telephone instead of in person, of course, and then delays in evaluations being requested, court hearings to decide appeal situations, and then to top it off, Social Security has also, they've been doing random audits. And so we've had people drawing Social Security where their situations are being questioned with regards to diagnosis, eligibility for benefits, et cetera. And then back payments where claims are eventually approved, back payments being made over a period of months, not all at one time as we have been accustomed to. And so there's a lot going on with Social Security. I just saw a letter today that a family received where they applied for SSI and a telephone interview was scheduled and they were on the phone ready for their telephone interview, but Social Security did not call. And a few days later, they got a letter and their application for SSI had been terminated or denied. And they right on the letter listed the fact that they had not participated in the telephone interview. And they read the letter and they were like, well, this is rich. We were on the phone and ready for the interview and Social Security failed to show up. And for that reason, right on the letter, it indicated that they had terminated the claim because of that the applicant was no longer interested because they had not participated in the call. So we're seeing a lot of challenging situations, but nevertheless, if a parent does pass away, retirement, disability, or if a mother or a father does pass away or die, then that is also a triggering event for an individual with special needs, and they can receive survivor benefits. So I have a situation right now. In fact, that the one, another one just yesterday we were working on, and the survivor benefit was $1,708 per month. So we're seeing survivor benefits now $1,600, $1,700, $1,800. Again, that's per month. And of course, families are like, does this last for a year or what? And reality is if an individual with special needs maintains their eligibility, survivor benefits actually can last a lifetime. So that would be receiving over $1,700 per month with cost of living increases for the rest of one's life. So while the government agencies and government benefits can be a hassle to deal with, my goodness, over the last 23 years, these benefits have become very substantial. And so it's really a good thing to have help from individuals like myself or Matt, to know what benefits to pursue. Now, Matt earlier was talking about on the screen that had like 0 to 18 or 18 and over. But we're seeing it's becoming more common to work with families who have adult children with disabilities, and they are not accessing all of the government benefits that they're entitled to. And so, case in point, that 64-year-old, believe it or not, that we were just talking about a moment ago, that has a 94-year-old mother. Well, at the urging of siblings, they just began exploring the Medicaid waiver for her when she was 61. And so often parents assume because their child is 35 or 40 or 45 or 50, 60, that the ship has sailed and that opportunities have passed them by. But I anticipate that within the next month, we will actually have an application in for a Medicaid waiver for the 64-year-old, believe it or not, because her issues are not related to being 64. These are issues she has had her entire life, but she has leaned on family, and family is getting old. And they need help. There's family fatigue, and they need help. And so, believe it or not, we're going to assist with planning at the grand age of 64 to get her a Medicaid waiver, to get her Medicaid for the first time at 64. Unbelievable. And on it goes. So again, the point being, don't think that the ship has sailed or opportunity has passed you by. There is help that we can provide almost at any age or circumstance. All that is required is that you request it. And of course, one of the benefits of this education series is that we are making available a free follow-up consultation. The email address, phone number, etc., is at the end of the slide presentation. But please do take advantage of the free consultation, because it doesn't matter whether you're at the beginning of your special needs journey or in the waning years of it. There are benefits in understanding and benefits in getting help, etc. Don't go it alone. Let us as a special needs community be helpful and supportive to you. That's what the Louisville Council is certainly all about. Okay. So again, on the family benefit side, when you start receiving Social Security retirement benefits as a parent, some members of your family may also qualify to receive benefits on your record. Now, I will tell you, one of the very first questions that I get asked is, does that come out of my benefit? And that's because the parent has paid into Social Security for decades. And while they love their child, they kind of feel like they've paid their dues and for years have been looking forward to that Social Security benefit, such as retirement. And the good news is that whatever an adult child with special needs draws off of a parent's record, it does not reduce the benefit that the parent draws. So parent draws what the parent's going to draw. The parent will draw more at 70 than 62, and it adjusts by close to 8% throughout that, meaning from 62 to 70. That's an 8-year span, 8 times 8 years at 8%. We're talking a span of close to, or basically 60 some odd percent, pretty scary. But it operates off of the full retirement age, which for most is 67 now. So if you look at 67 and then go down from 67 towards 62, for each year you move towards 62, the benefit reduces by approximately 8%. On the other hand, from 67 towards 70, for each year you move towards 70, the benefit goes up by approximately 8%. So these are decisions that individuals make with regards to their retirement. But when it comes to making those decisions when you have an adult child with special needs, it gets a little more complicated. And help is a really good thing, But this is part of what we do in the individual consultations is we will look at a family situation and we'll help determine if, as an example, if a mother or the parent that has the smaller income is going to draw off of the other parent, in other words, their spouse. And what that means to the adult child with special needs. And does a parent with a lesser income record, is it better off if they draw off of their own record? Setting the adult child free to draw off of the parent with a larger income. So again, these are really important decisions. They amount to literally hundreds of thousands of dollars over the lifetime of the family members. And let us give you some counsel. Let us help you make smart decisions. I do see differences of as much as $1,000 a month based on these decisions that are made. And Social Security is likely not going to educate you. And therefore you are left to make decisions in the dark, literally. And most of this can't be redone. So again, the decisions are so very important. And again, let us help. The survivor benefit that we talked about, again, these are substantial based on the parent's earning record. So the parent that passes away, the larger their income record, meaning the more income that they'd earned, the more substantial the benefit that is available. But these are the three areas that we were talking about, the three triggering events: the death, a parent dying prematurely before retirement, like the 52-year-old that I was speaking of a moment ago, or a parent becomes disabled, or parent reaches retirement. Now, one of the things that changed just a few years ago on reaching retirement, previous to about 4 or 5 years ago, we could do file and suspend. So a parent could reach 67 as an example and file for Social Security retirement and then suspend their benefit. And in suspending their benefit, because they had filed, the adult child benefit would start for their son or their daughter with special needs. That option was taken away. And now for an adult child with special needs to draw off of a parent, the parent has to file a claim and draw their benefit. So if a parent starts at 62, in many cases, the child right along with them, otherwise 67 or age 70, this type of thing. Please keep in mind that the closer one is a parent gets to age 67. And if they're driving their earnings up as they're approaching age 67, that's what has the most significant impact upon the benefit that your child is able to draw off of your record. What usually is most damaging is when the largest income earner retires at 62 and basically undermines potentially driving their benefit up in those 5 years to age 67. On the other hand, if a worker decides to wait till 70, it does not impact the adult child with special needs because their benefit will be calculated off of the age 67 benefit amount, the full retirement age benefit amount. In the example that we see on the screen, Rob has 3 children under the age of 18. He is eligible for $2,400 in monthly retirement benefits. A life event happens, his children under the age of 18 are eligible for approximately 50% of the eligible parent's benefit. So that's children under the age of 18. So if he gets 2,400, then that's 1,200 divided by, in this case, I guess they said three kids under 18. Okay, each child is eligible to receive these benefits until he or she turns 18. So 400 apiece, 1,200 divided by 3. As each child reaches the age of 18 and ages out of the benefit is equally split among the remaining children under the age of 18. So the first one that hits age 18, now we have the equivalent of 1,200 divided by 2. So each would take a raise from 400 to 600. And then when we're down to the last one, 1,200 up to $1,200. So this is also a factor, again, when it comes to a spouse drawing off of a spouse for retirement benefits, because we can have a spouse in essence competing with an adult child with special needs. So again, it gets a little complicated, but I enjoy looking at these situations, answering questions, and helping families draw conclusions. So we do have Q&A at the end. There have got to be questions about these Social Security issues and so forth, but we will probably be to the question and answer within the next 10, 15 minutes tops. So please make a note of your question, and hopefully we'll have some great questions or lively discussion as we get to that point. Oh, by the way, I perhaps should mention the qualification for the adult child benefit. And you can see here, children's disability benefit. If you qualify with a life event, meaning from a parent, your child with a disability also receives a benefit after their age 18, based on the parent's age 18 where their benefit would normally stop. So prior to 18, it's not based on the child's disability, it's just based on the child being a minor, being a child. Once they turn age 18 or 19, they're still in school, then it's going to be based on their diagnosis on their disability. So if if they would have been applying for SSI at age 18, in many cases they don't. The benefit transitions into an adult child benefit, from a child's disability benefit to an adult child benefit. However, the disability does, as it indicates here, has to be prior to the age of 22. So based on parents' earning record, provided the child's disability was before age 22. Parent prematurely dies before retirement. Parent becomes disabled. So the death triggers the survivor benefits we were talking about just a few minutes ago. The parent becomes disabled, and drawing Social Security disability triggers the benefit for the child, or much more of a happy dance. The parent makes it to retirement and starts drawing retirement benefits. So there's just, I mean, gosh, thousands and thousands of people that are facing these issues on a daily basis, and it's just challenging as well as scary to try to make decisions in the dark on these things without understanding. So we have another example. John is an adult who became disabled prior to the age of 22. So he met the age requirement with a disability occurring before 22. You might be curious, what's with 22? Who decided that was the magic age? Well, the legislation was written many years ago when you graduated from high school and most went to work. And therefore, if you went to work at 18, 19 years of age at the latest, by age 22, you were insured for Social Security disability. Therefore, you didn't need to draw off of a parent's record. You had your own. So that's why they put into the law that the disability had to evidence itself prior to 22, meaning the individual with a disability never had the opportunity to build their own earnings record for Social Security, and therefore default to drawing off of a parent. And again, the child, as we discussed earlier, may receive up to 50% of his parent's benefit. If it is a separate benefit, it does not decrease the amount paid to the parent. What we were saying earlier, they don't discount the parent's benefit. Okay. Medicare. We think of Medicare, of course, as something that's associated with age 65. And that's true. However, Medicare is very much a benefit for the disabled as well. So Medicare coverage is the same for people who qualify based on disability as it is for those qualifying based on age, such as turning 65. For those who are eligible, the full range of Medicare benefits are available. Coverage includes certain hospital and nursing home care. That would be your Part A, home health, physician, and community-based services, your Part B, and home and healthcare services that do not have to be related to the individual's disability. Eligibility for Medicare includes anyone who has a disability due to receiving SSI, meaning they are considered Social Security disabled. They have ALS, otherwise known as Lou Gehrig's disease, or end-stage renal failure. And these are simply conditions that certain lobbying groups got to Congress, got their ear, and so preferential treatment was built into the legislation. Just like favorable treatment was built in for those that are blind or visually impaired with regards to the SGA or substantial gainful activity limit. So there are kind of unique situations that people lobbied and got. Public assistance, again, SSI, non-medical, designed for people typically under the age of 65 or blind, like we were just saying, people with disabilities who have little or no income, disability expected to last, not a flash in the pan. And Medicaid typically comes with it. In Indiana, it does. So, and Kentucky. So if you're in either state, qualifying for SSI is an automatic qualification for Medicaid. And of course, to qualify for either, your resources have to be under $2,000. So I've got a conference call with an attorney tomorrow morning with a son, a mother and her son, because they have actually applied for Social Security and have been turned down repeatedly. And next month is the final hearing. So it's the final hearing before a judge, and the decision will be made about Social Security. Well, this has been going on for years, and in the interim, he has accumulated over $30,000. So wouldn't it be rich to have fought for Social Security for year after year, appeal after appeal, only to be turned down because you have $30,000? So knowing that that hearing is coming just in a matter of weeks, we have a call tomorrow morning to to discuss the situation and how we can deal with his having $31,000 too much, basically in the way of available resources. Like I mentioned earlier, most everything with special needs is fixable on the benefit side. It's knowing how to work with all of this. Okay, state waivers, and waivers vary by state. So please keep a couple of things in mind. If parents move from state to state, it can upset the apple cart on Medicaid waivers. So if somebody has a Michelle P waiver or has a SCL Supports for Community Living waiver, you might want to think twice about uprooting them and taking them to Illinois or Ohio or something, because they may be at the back of the list, the waiting list for a Medicaid waiver. You know, even in Kentucky, the Michelle P has about a 10-year wait. So if you've got something that takes that long to get, please think twice before losing it. Very, very important. And then the other programs, including the children's with special healthcare needs. So, and again, these things vary by state, but are well worth exploring. So we're heading toward a summary here as we get close to the time for Q&A. But as Matt did a wonderful job of talking about the letter of intent, and the good news is we do have a fillable Word document. So you don't have to write it out and then, a month later it's out of date. It can be built into the fillable Word document, and then you can edit it and update it as information changes. Really powerful. The guardianship issue, who's going to be trustee and who's going to succeed as trustee. Getting a will, what's going to happen to your house, your cars, your bank account, your furniture, your clothing and personal items, your tools, your guns, whatever it is that you have. Wills are so very, very important and inexpensive. Advanced medical directives, who's going to make those healthcare decisions? Do you want family arguing among each other? Who's going to take over the checking account and pay your bills and so forth while you're incapacitated? So there are a number of issues that are a part of the planning process, and we do a lot of hand-holding to help families step by step get through the process to get to the finish line. And it's a joy, certainly, to do so. Okay, so this is the busiest slide in the whole presentation, and it's because there wasn't much on ABLE in this presentation, and I decided to beef it up. So blame me if you like, but we'll go through these points about ABLE accounts, and then I believe after that we're going to go to questions. All right. The Achieving a Better Life Experience, or ABLE Act, signed into law about almost 7 years ago. And individuals with disability At the moment, at least, the disability needs to have occurred prior to age 26 or the origin of it at least. And this is kind of the answer to 529 college savings plans. But if the age criteria is met, you can set up an ABLE and set monies aside in it. It is after-tax dollars that go in, it grows tax-free and distributes tax-free. The total limit over time to put into the plan is $300,000. And working account owners who do not participate in an employer-sponsored retirement plan may be eligible to contribute above the annual ABLE contribution limit. So we've got the limit for 2020. We need to update that, but you can put quite a bit into an ABLE account. Do remember, though, there is a Medicaid payback on these accounts. And so it's a put and take or save and spend type of idea. But if you have resources that are a problem, that is you're above 2,000 wondering what to do and spending it is really not an option because your needs are met, then an ABLE account can be an effective tool to set funds aside or handle a small inheritance, a small legal settlement, etc. Okay, and again, we're providing the opportunity for a free follow-up consultation. We encourage you all to take advantage of that. I just threw onto this slide questions and also the example just this week of the 64-year-old that we had a Zoom meeting with earlier today, a 33-year-old for tomorrow morning, and then sandwiched between them was the 2-year-old with Down syndrome. So special needs knows no barriers. It affects all of us. But at this point, we're at 7:40, so we have, as promised, a healthy amount of time left for questions. And let's go to the, okay, so, all right, questions are starting to come in. Thank you so much for that. I'm so thankful. I know Matt and I both enjoy answering questions and being helpful in that way. So let's see, a question from Lisa says, does a disabled adult receiving SSDI under a parent be covered by both Medicare and Medicaid and the Michelle P. waiver? So Lisa's question is, can you have it all? And the answer is yes, you can. There are certain limits, guidelines to observe, but an individual can draw off of their own record, if they have one, off of a parent's record. They can, in addition to that, have Medicare. And in fact, most anyone that draws Social Security disability off of themselves or of a parent, 2 years later will become Medicare eligible. When a child becomes Medicare eligible, I can't tell you how many parents have emailed me very concerned because the presumption is, since they're getting Medicare and they have health care, that Medicaid will boot them off. And the answer is, in most cases, no. It is possible to maintain Medicaid and Medicaid waiver services, whether the Michelle P. home and community-based SCL, et cetera, while having Social Security disability income and earned income. So yes, it's possible to have earned income, Social Security disability, maybe a little bit of SSI if it works, Medicaid, Medicare, waiver, and so forth. Yes, and I know of many families where the family member with special needs does have all of that simultaneously, and it's worth hundreds of thousands of dollars. It's really powerful. Okay, let's see, Matt, are you able to see the second question?
Yeah. So what is the maximum amount my child can have in his ABLE account before it will affect benefits? So for our purposes, again, our maximum contributions annually, so per year, is $15,000. That matches the annual gift tax exclusion. But for our purposes, if the individual is receiving SSI, our cap is $100,000. Anything above that amount will begin to impact eligibility. So for SSI, you can only have $2,000 in resources, which we've mentioned. If there were $103,000 in a stable account, which is what it's called in Kentucky, that $3,000 over our $100,000 threshold would count against the individual. So we would have to spend down $1,000 or somehow get rid of $1,000 to get back to $2,000. This is assuming the child doesn't have any other assets out there, any other bank accounts, etc. So for our purposes, $100,000 is our magic number.
All right, thanks, Matt. Let's see the next one. Okay, does my child have to go through the disability determination process with Social Security, even if they have the medical condition on the list and it occurred prior to age 18, specifically autism? Do they try to say your child is not disabled enough? So, okay. The most common journey is prior to the age of 18, pursuing a Medicaid waiver. If the family has meets the financial criteria, then the child may, prior to the age of 18, receive SSI. But if not before 18, then many parents are applying for SSI once they turn age 18. Now, I think there's a couple of different ways to take this question, and we'll kind of run it both ways. One is that perhaps the child via Medicaid and the Michelle P. waiver has been acknowledged to have special needs or a disability prior to the age of 18, and or maybe Social Security approved them for SSI prior to the age of 18. So to answer this question, because the question was put forth from a Social Security standpoint, not a Medicaid standpoint. So the answer is basically yes. They are going to have to, for Social Security purposes, receiving SSI prior to the age of 18 is not tantamount to an automatic continuation as an adult. The qualification prior to the age of 18 is based on a combination of family finances and diagnosis. Once the child reaches age 18, in essence, they drop kick the financial criteria for the family and replace it with the requirement that we're able to substantiate that the individual is not capable of SGA or substantial gainful activity. You could call it full-time employment. It's measured in terms of earned income, which for 2021 is $1,310 per month. So prior to 18, chances are an autism diagnosis, either being on the waiting list for, having the Michelle P. waiver, having an IEP, would be enough for the child to qualify for SSI if the family met the financial criteria. However, once they turn age 18, then the financial criteria not only is dropped for the family, continues to apply to the individual receiving services, and they want to know whether the 18 or over individual can perform substantial gainful activity. So there is a requalification, unfortunately, that occurs when one goes into adulthood. Just like as we discussed in session 2, if for some reason there's guardianship when they're young, that has to be resubmitted, reevaluated once they turn age 18 as well. So there is a bit of a passage issue between under 18 and over 18. I think there may be a fourth question. Let's see what it is. We love questions, so please continue to share them. Matt, do you want to help us with this one?
Yeah, so it says, is the $2,000 asset limit or resource limit in effect if the disabled adult is drawing SSDI, but is covered by Medicaid only through the Michelle P. waiver? So the answer is yes. So it's important to keep in mind when we were talking about our two categories of public benefits, means tested and non-means tested. Our means tested benefits, SSI and Medicaid and the Medicaid waivers, all have that $2,000 resource limit that you have to meet in order to be eligible. On the flip side, our non-means tested benefits, such as SSDI and Medicare, do not. However, there are many instances in which an individual with special needs is receiving both. So in this example, the child may be receiving SSDI benefits, which doesn't by itself have that $2,000 resource limit. However, most of the time they're also receiving the Michelle P. waiver or other Medicaid waivers and disability Medicaid, which does have the $2,000 resource limit. So if Medicaid or the Michelle P. waiver or other Medicaid waivers are involved, regardless of the type of Social Security benefit being received, you still have to meet that $2,000 resource requirement. So it's not being imposed based on the recipient's SSDI benefits. It's being imposed based off the Medicaid and the Michelle P. waiver. So keep that in mind. You still have to meet it.
So to tag on what Matt is saying, I do occasionally run into a family situation where the adult individual with a disability is drawing SSDI, as is mentioned in this fourth question. And they're drawing it in a lot of cases because of a parent. And because they're drawing SSDI, they also have Medicare, but they never had Medicaid. They never had a Medicaid waiver. And so as is suggested again here, the 2000 is not an issue because the SSDI and Medicare are entitlements. They're not needs-based benefits. And so in that scenario, quite often, it becomes an issue of the siblings pushing for waiver services because the individual cannot live independently and the parent or parents are fading, dying, retiring, unable to provide care, etc. And the siblings are not warming up to the idea of doing everything that mom and dad had done. And of course, have children and lives of their own, etc. And so the Medicaid and the waiver issue can pop up as late as like 64, like the meeting I had earlier today. If in the meantime, because there was no Medicaid or waiver services, the individual with a disability has accumulated assets, not unusual at all. They didn't have to pay for anything. Their Social Security benefit may have gotten banked or part-time income or who knows what may have accumulated and nobody said anything because no Medicaid. Then suddenly they're in their 40s, 50s, or 60s. Siblings are pushing the issue. You need to get Medicaid waiver services in there and they're not eligible because they have 10,000, 20,000, 30,000. If it's a small amount, it can be thrown into an ABLE account. But if you're talking 30, 40, 50,000, an ABLE won't work. And so we do in some cases use the first party special needs trust that we talked about last week. But assets can be set aside to make them eligible for waiver services. So those are really interesting situations. Great question. Thank you so much. And one more, it appears, from maybe the same person. I'm so thankful. Okay, my parents have created a special needs trust for my son. So that sounds like grandparents creating a special needs trust for a grandson in their will. Should I create a second trust in my own will, or is there a way to combine it with theirs? Matt, help us out.
Yeah, so the first thing that comes to mind here when I'm reading the question is that it was said that it was created in the grandparents' will, which dictates the outcome to the question of, can I combine it? Typically, if a trust is created in someone's will, it's called a testamentary trust. So for our special needs trust context, if we have a testamentary special needs trust, that means it's created or written into someone's will. It's not its own standalone document. If that's the case, typically the only people that can contribute to that trust are the individuals that wrote the will. So the funding source is only going to come from the person once they pass away. The property's administered through their will and then goes to the trust. Conversely,
allow me to add in on that, because it's a matter of whether this family wants to take a risk.
Mhm.
And the risk is, does anybody die before the grandparents?
Mm-hmm.
And that's the problem, because like Matt said, this trust cannot be used until the grandparents have passed, and chances are the second one of the grandparents has to pass. because usually, grandparents, they've been married a while and they leave everything to the surviving spouse, and then the special needs trust wouldn't come into play until the second grandparent dies. Well, grandparents are living a long time these days. We're seeing plenty of them in their 90s. And the risk that exists here is if something happens to a parent or parents before the grandparents. And in fact, that was the case today because one of the siblings of that 64-year-old had already passed, and there the grandmother is, or the mother, is still living at 94. So ideally, the parent or parents would set up their own special needs trust, and then the grandparents can stick with their existing plan or actually consider updating their plan to leave assets to the trust set up by the parents. So what do you think, Matt? I mean, an opportunity to kind of expand on things.
Yeah, I think the best scenario here is for parents to set up a standalone special needs trust. What I mean by that, it's kind of the opposite from the testamentary trust. So it's its own trust document, separate from your will. That gives you a little bit more flexibility in terms of when assets can pour into it. You don't have to wait until someone passes away. You can immediately place money or assets into the trust in a standalone trust context, or it also makes it more flexible from a funding perspective. So who can contribute? Again, in the testamentary context, typically only the person for whom the will was written can contribute. Standalone trust context, anyone can contribute. So if parents set up a standalone special needs trust for son with special needs, they can contribute to it, and then also the grandparents can contribute to it. So they may then revise or revisit their estate plan and name the trust that the parents have set up to make it more efficient. Then it's just one trust. We don't have multiple trusts in place, et cetera. So I think that's the best scenario, the most efficient plan based on what we have here.
In addition to that, we do have a lot of blended family situations with special needs. And I know Matt and I are frequently asked, can an individual have more than one special needs trust? And the answer is yes. So if we have a mother and a father that maybe were never married, or they've divorced, maybe they've remarried, et cetera, then, each parent or grandparent, can set up a special needs trust. So for efficiency's sake, like Matt said, we try not to make them a dime a dozen, but it is possible if kind of agendas or thoughts on who might be the trustee or play a different role in the estate plan vary, meaning everyone doesn't see things exactly alike. An individual can have more than one special needs trust. So I'm so thankful for these questions. We have just a few minutes left. Any other questions anyone would like to ask? Maybe you're facing a real life situation right now and are interested in the input. We just have a few minutes left before we wrap up. Let's see. So I know that part of what I enjoy with special needs is not only making a difference for people, but the situations are so varied. No two situations are alike or are identical. And every family that we meet with, it's meeting them on their terms and their circumstances, making a difference for them. And almost 100% of the time, there is a way to impact the situation favorably. So despite how challenging you feel your situation is, or how hopeless you may feel that it is, et cetera, that's part of the reason for giving you the free consultation, so that we remove any roadblocks or any hesitancy that anyone would have to getting help, that type of thing. And speaking of that, here is the information to bring us home. If you can email either email address on the screen, or you should be getting pre and post email messages. There should be an email going out as a follow-up to this evening's workshop. and you can respond to that email to request your free follow-up consultation, or email to the email on the screen this evening. Let's see, no additional questions have come in. So I do want to once again thank the Louisville Council on Developmental Disabilities for being so gracious. They worked hard to make this series successful. And there were multiple meetings that planning meetings that went into this. I can tell you from experience that I've had few events that I've participated in and worked in where there was certainly as great an effort as the Louisville Council put into making this a success. So I know I speak for Matt when I say thank you to Kelsey and Sarah Beth and the whole Louisville Council crew for pulling this off. These are being recorded, so make sure to check the website to replay for anyone that you know that may have not been able to participate. And then we've already started discussions about revisiting these topics because every year things change. The presentation these last 4 nights would not have been the same as little as a year ago. And so we look forward to bringing you new and updated information in the future. The extent to which this has been helpful, the Louisville Council would love to hear from you because they, of course, measure programs and their value based on outpouring and response from the community. So do feel free to email or give the council a call to let them know how helpful this has been for you. And please let us hear from you with regards to the free consultation. Matt, Kelsey, anything you want to add as we reach 8 o'clock?
Thank you guys so much for doing this. We really appreciate it.
Gordon, I'll just add, thank you guys for attending. Again, if you have any feedback, we'd love to hear it. We always want to make these presentations as best as we can moving forward. And again, if you've missed any of the presentations so far, they are recorded. They are going to be made available, so be on the lookout for those. And we look forward to seeing you guys hopefully in those free consultations. Let us help you guys. So thank you all.
All right. Good night.
Night.
Right.